gentleman is currently facing a total of 8 charges. We have a third-degree burglary, a third-degree theft, a disorderly person's criminal trespass, a fourth-degree criminal mischief, a fourth-degree hindering, a fourth-degree resisting eluding, a third-degree resisting eluding, and a third-degree possession of CDS. Based on the totality of circumstances, the court finds that probable cause has been established that Mr. Ortiz is an eligible defendant. Accordingly, probable cause is found for all 8 charges to issue. Gentlemen, let's turn our attention now to the issue of detention. I'm looking at the public safety assessment. The public safety assessment gives us the highest scores possible, a 6 for failure to appear, a 6 for new criminal activity. There's no new criminal activity flag, and the recommendation is no release. Mr. Brown, I'll hear from the state on the issue of detention, please.
Thank you, Your Honor. The PSA properly recommends no release. Risk of danger is demonstrated by the current charges in which defendant broke into a vehicle and stole $3,500 worth of tools and then physically resisted while being arrested for that burglary. Risk of danger is amplified by defendant's 10 indictable convictions and 11 DP convictions, which together include burglary, various species of theft 6 times, forgery, identity crime, and 7 offenses arising from his possession and distribution of CDS in our community. Danger is echoed in defendant's 16 pending offenses, which include ag assault with an unlawful handgun, while already a certain person not to possess any weapons, 2 theft offenses, and 8 more CDS offenses. Risk of danger is further demonstrated by the 6 DV restraining orders defendant has earned, with underlying offenses of assault, harassment, and terroristic threats. Risk of flight and obstruction are demonstrated by the current charges, in which defendant attempted to flee, then fight police to the point of needing to be tased multiple times before being subdued. The risks of flight and obstruction are amplified by defendant's convictions for resisting twice, hindering also twice, and obstruction. It is further amplified by pending charges of 2 more hindering and obstruction offenses. Risks of flight and obstruction are further demonstrated by defendant's 22 failures to appear, of which 2 are recent. Defendant's convictions led to 11 sentences of incarceration of as long as 3 and 4 years apiece, which have done nothing to mediate defendant's dangerous criminal conduct. Wherefore, the state respectfully requests the court follow the recommendation of the PSA and detain defendant pre-trial.
Very good. Mr. Bayak, I'll now hear from you on the issue of your client's continued detention.
Thank you, Judge. I wanted to point out a mistake on the public safety assessment. If we look on page 3 of that assessment under the pending charges, the bottom 3 charges listed, and just to make sure I have them right to the court, looks like a 4th degree ag assault, the pointing charge, the 4th degree certain persons, and then a 1st degree possession of a weapon. That was part of a case where that whole entire case was dismissed. There was about 5-6 charges in total. I'm not sure why just 3 of those charges are showing up. Everything in its entirety was dismissed, so that shouldn't show up at all. I had represented Mr. Ortiz on that case, as well as the other pending matters, but that matter is actually not pending anymore. That was dismissed in its entirety. I think that's important. While even if we take it out of the equation, the state certainly has an argument as to why Your Honor should detain Mr. Ortiz. But I think there's a big difference with somebody with convictions that are drug or drug related. And by that, I mean like burglaries, thefts, shopliftings, things all aimed at getting money or obtaining drugs one way or another. When you have something that's violent, I think that's a very different story from the court's perspective, because one of the things obviously Your Honor is going to consider is the safety of the community or whether Mr. Ortiz is a danger. So I needed to point that out, Judge. That case was dismissed in its entirety. But aside from that, Mr. Ortiz is 49 years old. Prior to me picking up, he was working for J&R Landscaping. I know that's a job he's had, I think, for pretty much the entire time I've represented him. While I know that there are failures to appear here, Judge, I think everything centers in this case around substance abuse issues here. I know Mr. Ortiz would be willing to do whatever he's got to do to get himself in the right place. Although he didn't appear at a prior date, up until that point, he was always very cooperative with me. He'd stay in touch with me. He was never a problem from my end, obviously, until not showing up. But again, Judge, I think this is something that's really just centered around drugs. There's no violence other than obviously we have a resisting allegation here, but the prior handguns, all that should not be a pending charge. With all that, Judge, I think there could be conditions the court could put in place for Mr. Ortiz. I know that there are other holds out there, but assuming those get addressed one way or another, I still would ask the court to consider release in this case. Thank you.
Thank you. Mr. Brown, anything else from the state?
Only that I just looked. I don't have any information about the 3 charges that Mr. Bayak has described as being dismissed and not properly on PSA. But I'll take Mr. Bayak at his word, and just for the appellate record, ask the court to not consider those 3 charges in your determination today, so it's not a factor. But to be perfectly frank, I think even without those 3, my argument doesn't change at all.
Very good. All right, gentlemen. This is the prosecutor's motion for pretrial detention in the matters of State versus Ismael Ortiz. Complaint warrants W2025-004-579-0102, as well as complaint warrant W2025-006-02-0102. Mr. Ortiz is 49 years old, a resident of Atlantic City, and it appears that his ties are all to Atlantic City. He is gainfully employed with a landscaping service and has been with them for a considerable amount of time. The court is looking at the public safety assessment and does note that this gentleman is facing the 8 charges that were previously detailed. And at the time of this offense, the PSA indicates that there were 16 charges pending. However, Mr. Bayak has noted that 3 of the charges were actually dismissed. The court will not give any weight to those, but the court will still consider that there were 13 pending charges at the time of this offense, all of them ranging between 2019, 2020, 2021, 2023, and 2025. They include 2 counts of hindering, shoplifting, theft, possession of drug paraphernalia, more than once, possession of CDS, more than once, obstruction, again for possession with failure to turn over a CDS, more paraphernalia. Most of them appear to be hindering, shoplifting, and CDS related. He does have 11 prior disorderly person convictions. We have 2 for possession of CDS, or I should say failure to turn over, hindering by giving false information, theft by deception, obstruction, possession of prescription legend drugs, again, shoplifting, hindering, identity crime, resisting, eluding, 10 prior indictable convictions, all in the 3rd and 4th degree level, again, shoplifting and CDS related, burglary, forgery, conspiracy to commit theft. With all of these prior convictions, none of them are identified as prior violent convictions. Although he has 2 prior failures to appear in the last 2 years, he has 20 prior failures to appear before that. 1996, 1997, 2001, 2007, 2018, 2019, 2020, 2022. He has 11 significant periods of incarceration. 1998 for 4 years, again for 4 years in 1998, 90 days in 2003. Looks like he got a 3-year aggregate in 2005, another 90-day sentence in 2008, a 364 in 2010 and 2011, a 3-year sentence in 2016, 220-day sentences in 2020. He is not currently on probation, not currently on pretrial monitoring, not currently on parole. There is a history of 6 domestic violence restraining orders. 2 of them are active final restraining orders. The others have been dismissed. Those that are active were based on acts of assault and 1 for acts of harassment. There are reported holds. As indicated, there are 2 holds, one of them being from recovery court in Atlantic County. Both of those holds are no bail. Based on all that information, the public safety assessment gives us a score of 6 for failure to appear, a 6 for new criminal activity, no new violent criminal activity flag. The recommendation is no release. The court will now address the triad, beginning with failure to appear. Although the court notes that there are only 2 noted failures to appear within the last 2 years, the court cannot ignore that there is a history of 20 others where this gentleman has failed to appear as required or as directed. The court has great concerns for this gentleman being a risk to be a failure to appear. As to the safety of this victim, those similarly situated or the community at large, the court has great concerns there. The Stanley Homes Village, historically one of the first public safety housing residences in the country, that this gentleman had gone into a gated area, actually broke the window of a truck and removed approximately $3,500 in equipment. And when found a few weeks later, or a few days later, I should say, gave false information, false name, physically resisted, and all while being in possession reportedly of CDS. So the greatest concerns that the court has is the safety of the victim, the community at large, this being on public property, and the obstruction of justice in his, not only with what is alleged on November the 2nd of 2025, but looking at his history of prior convictions for obstructive behavior. So based upon the totality of the circumstances, including his criminal history, the recommendations of the PSA, and the facts of both of these cases, the court finds that the state has established that there is no amount of monetary bail, non-monetary bail conditions of pretrial release, or a combination thereof that would reasonably assure Mr. Ortiz's appearance in court required, the protection or safety of any victim or our community at large, or that he would not obstruct or attempt to obstruct our criminal justice process. Here, the state has met its burden by clear and convincing evidence based upon the documents presented to the court, including the recommendations of the PSA. Therefore, detention is ordered on both of these matters. Mr. Ortiz, you have 7 days to appeal my determination, and you shall be afforded reasonable opportunity for private consultation with counsel. The next court date I have for this gentleman on these matters is December 17th, 2025. That's a pre-indictment conference, and that is before Team F. Mr. Bayak, has this gentleman made a recovery court application on these new charges?
No, Judge, I just got the file yesterday. I wasn't sure with the recovery court hold, does it automatically come right back to Your Honor in recovery court, or do we need to do another application, or what happens there?
I would just want to make sure if he does want to still be considered for inclusion in the recovery court, that at least there's an application on these new charges so that we could look at everything and as a whole.
I'm going to go see Mr. Ortiz in the county jail. I won't get there today, but I'll get there early next week. And if that's what he wants to do, we'll get that application in, Judge.
Very good. And, you know, with the concerns that you brought up as far as a possible substance use disorder, that might be something for Mr. Ortiz to really consider if he's serious about addressing that.
I'll speak with him about that, Judge, and see where we go from there.
All right, Mr. Bayak, anything else for this gentleman?
That'll be it for today, Judge. Thank you.
All right, Mr. Brown, anything else from the state?
Nothing further from the state, Your Honor. Thank you.
All right, Mr. Ortiz, that is all for today, sir. You may remove yourself from the booth and have them send the next person in.